Hello and welcome back to Module 8. This module is on TUPE and dismissal. Now, employees get extra protection against dismissal when there's a TUPE transfer. Employees still have to have 2 years continuous service to bring a TUPE unfair dismissal claim, but certain dismissals are automatically unfair if the sole or principal reason for the dismissal is the transfer. Now, automatic unfair dismissals are different from normal unfair dismissal cases. In a normal unfair dismissal case, an employer first has to show they have one of the 5 potentially fair reasons to dismiss: conduct, capability, redundancy, breach of a statutory enactment, some other substantial reason. So that's stage 1, proving the reason. Stage 2 is they've got to satisfy the reasonableness test by showing that the decision to dismiss was reasonable in all the circumstances. Now, in automatic unfair dismissals, there's no reasonableness test. If the sole or principal reason for the dismissal is the transfer, the unfair dismissal claim succeeds automatically. And the extra protection applies to any employee of the transferor or transferee who's dismissed because of the transfer, not just those assigned to the organised grouping of employees which transfers, or the organised grouping of resources which transfers. It's all affected employees who are protected. Now, if the sole or principal reason for the dismissal isn't the TUPE transfer itself, but is an economic, technical, or organisational reason entailing changes in the workforce, then the dismissal is potentially unfair. That means that the employer still needs to show it's acted reasonably in all the circumstances. Now, theoretically, an employee without 2 years' service can bring a claim under Section 104(4)(e) of the Employment Rights Act 1996 that they were dismissed for asserting their statutory rights under TUPE. But that's really difficult to do and really difficult to fit within the statutory framework. In the rest of this module, Module 8, we'll discuss dismissals where the sole or principal reason is the transfer, dismissals for an economic, technical or organisational reason entailing changes in the workforce, who carries the can, and the 2 types of deemed dismissal. Who carries the can is a little bit complicated and it's quite fiddly, but bear with me. Let's start with dismissals where the sole or principal reason is the transfer. In these cases, much turns on what the transfer means. There can be a lot of argument over it. Often the question is whether the employee was dismissed because of the transfer or for another reason connected with the transfer, when the softer set of rules applies and it's still possible to prove reasonableness if it's an ETO reason. Often the argument is the transfer a coincidence or a cause. The real reason is a question of fact for the employment tribunal to decide, and very often these things can just go either way, and it's an element of good witnesses, good advocates, lucky pick of the judge, and how things go on the day. In a case called Hare, Wines and Cower, the Court of Appeal agreed an employee had been dismissed because the transferee didn't want her due to a poor working relationship with a future director. The transfer wasn't coincidental, it was the sole or principal reason for the dismissal, rather than the poor relationship itself being the principal reason. That meant the dismissal was automatically unfair. Now, you might remember, casting your mind back many years, that dismissals connected with a transfer also used to be automatically unfair before 2014 when TUPE was amended. So transfer-related dismissals, we still have them of course for a reason related to the transfer, which were previously found to be connected with the transfer, still might be 51% or more because of the transfer, and so still might satisfy the sole or principal reason test, leading to a finding of automatic unfair dismissal. Let me turn to talk about dismissals for an economic, technical or organisational reason entailing changes in the workforce. Now, the normal rules of unfair dismissal law apply to dismissals for an ETO reason. To avoid an unfairness finding, you've got to show 1, that the dismissal was for an ETO reason entailing changes in the workforce, and then 2, that the dismissal was reasonable in all the circumstances, the classic Section 98(4) of the Employment Rights Act test. Now that means following a fair procedure, including the ACAS Code of Practice if it applies, or a fair procedure in redundancy cases. The economic, technical or organisational dismissal will be for some other substantial reason or for redundancy, depending on the facts. Now, to be potentially fair, the dismissal has to not only be for an economic, technical or organisational reason, it also has to entail changes in the workforce. But what is an ETO reason? The ETO defence makes sure that employees can be dismissed for a legitimate business reason when there's a TUPE transfer. An ETO reason relates to the day-to-day running of the business. So an economic reason, ETO, economic reason, might relate to the profitability of the employer or its market performance. In a case called Crystal Palace against Kavanagh, a struggling football club, Crystal Palace, had gone into administration. That's a type of insolvency. The administrator dismissed some of the club staff to allow Crystal Palace to keep trading, but not to make Crystal Palace easier to sell. That was an economic reason. ETO, a technical reason, might relate to the transferees, the incoming employer's equipment, or the transferee's production process. For example, the dismissal of employees might be for a technical reason if the transferee, the new employer, uses new technology to do the work and the transferring employees don't have the relevant skills to use it. ETO, an organisational reason, might relate to the management of the business or its organisational structure. So, for example, in a case called Nationwide against Ben, the transferee had a narrower product range than the transferor, the old employer. That narrower product range was an organisational reason which led to detrimental changes being made to employee roles, to their pay, and eventually to their dismissal. So you need to establish the ETO reason, but it also has to entail changes in the workforce. And what does that mean? The word workforce isn't defined in TUPE, but it means the people, the workers, the employees of the business. Changes in the workforce can include things like a change of location of the business. So dismissals that result from a relocation will be potentially fair for redundancy, rather than automatically unfair because they're connected to a TUPE transfer. A change in the number of employees, including genuine redundancies, is a potentially fair reason, entailing changes in the workforce. A change in the functions performed by employees. So this might include changes in employee roles due to differences in operational structures between transferor and transferee, or a change in job function from managerial to non-managerial, for example, or changes from an administrative function to a sales function. Now, the changes in function don't necessarily have to affect the whole workforce, but they should affect a body of transferring employees. It's a question of degree. Minor or trivial functional changes relating to only a few employees in a big workforce might not be enough. And the change in function has to directly affect the employee who's been dismissed. So the affected employee has to be part of the workforce to which those functional changes apply. That's logical. Changes to employee functions in one part of a workforce can't be used to justify dismissals in another part. And trivial changes to an employee's functions aren't going to be enough. Adding additional minor jobs to a cleaning role might not be enough to meet the new test. Use this feather duster instead of this feather duster. Adding in significant new cleaning requirements or responsibilities might. This is a really tricky area. Dismissals caused by attempts to reduce salary and benefits might struggle to meet the ETO test. The changes in the workforce need to happen at the same time as a dismissal. So in Hazel and Manchester College, 6 months after a transfer, the employer decided to make 200 redundancies and harmonise terms of employment to save costs. Most employees signed up to the new terms, but 2 refused and were dismissed. The employer said it had an ETO reason for the dismissals, and the changes in the workforce were the 200 redundancies which sat alongside the harmonisation process. Court of Appeal said no. Court of Appeal said the redundancy process was there and it had finished by the time the new terms of employment were offered to employees, although the dismissals for refusing to sign up to new terms were for an economic, technical or organisational reason, harmonising terms, saving costs, they didn't entail changes in the numbers or functions of the workforce. Now, this is a complicated issue. Who is actually responsible? Who pays the bill? Who is liable? Transferors and transferees will often agree that dismissals should be made before any transfer takes place. Who takes responsibility for those dismissals depends on the reason for them. So, for dismissals before the transfer, where the reason for the dismissal is the transfer, the dismissal is automatically unfair and the transferee will be liable for the dismissal. That's because if the reason for the dismissal is the transfer, then liability moves over automatically under TUPE. The position is different for pre-transfer dismissals where there's an economic, technical or organisational reason, but the dismissal is procedurally unfair under the normal unfair dismissal rules. In that situation, because the dismissal isn't automatically unfair because of the transfer, liability doesn't move to the transferee, and the transferor, the old employer, remains liable. The same goes for a dismissal before a transfer where the reason is not the transfer. Normal unfair dismissal rules apply, liability stays with the transferor. What about dismissals after the transfer? Well, that's easy. The transferee, the new employer, carries the can. The transferee will be liable for automatic unfair dismissal if the reason for the dismissal is the transfer. The transferee is liable for any post-transfer dismissal if there's an ETO reason, but the dismissal is unfair under normal unfair dismissal rules. And of course, the transferee is liable for any post-transfer dismissal, which has nothing to do with the transfer, but unfair under normal unfair dismissal rules, because by then employment has moved. There are two types of deemed dismissals under TUPE. First of all, the traditional constructive dismissal. Second of all, a resignation in circumstances where changes are being made that don't amount to a constructive dismissal, but are to the material detriment of somebody who's transferred. And people who resign in these circumstances are treated as having been dismissed, and they benefit from the enhanced protection TUPE provides for dismissals which are due to a transfer. Let's address those two situations in turn. Constructive dismissal first. Under Regulation 411, 4 sub Reg 11, TUPE preserves an employee's right to resign in response to the employer's repudiatory breach of contract. Like any other TUPE dismissal, a constructive dismissal will be automatically unfair if the reason for the dismissal is the transfer. If the sole or principal reason is an economic, technical, organisational reason, it's potentially unfair and the normal unfair dismissal rules will apply. What about the second one, which is specific to TUPE? Under Regulation 4.9, an employee can resign if the transfer involves a substantial change to their working conditions to their material detriment. No breach of contract's required here. You don't need to breach the contract as the employer, so technically it's not a constructive dismissal, but it's kind of a deemed constructive dismissal. How does it work? Well, let's imagine a classic situation where the employee is entitled to a non-contractual bonus, and that amounts to a fairly substantial amount of their remuneration. The transferee, the incoming employer, decides not to pay a bonus. Now, legally, contractually, they can do that because there's no contractual entitlement to the bonus. Let's just park the mutual term of trust and confidence here for argument's sake. So the transferee hasn't constructively dismissed the employee by refusing to pay a bonus because it's not a breach of contract. But under Regulation 4.9, it will be a substantial change in their working conditions. Conditions has a very wide meaning, to their material detriment. They're being paid a lot less. That entitles them to resign and claim effectively constructive dismissal. And if the reason for the cancellation of the bonus was the TUPE transfer, it's an automatically unfair constructive dismissal. So the employee's resignation becomes a dismissal. It isn't necessarily unfair, of course. It just creates the opportunity for an employee to argue it was unfair. But if the sole or principal reason for the detrimental treatment was the transfer, which in many cases it will be, the dismissal is automatically unfair, as I said. Who carries the can for deemed dismissals? Well, it depends on the facts. If the dismissal is before the transfer, but because of it, the employee still transfers to the transferee, even if they've technically been dismissed beforehand, because employees will transfer if they would have been employed immediately before the transfer, but for being automatically unfairly dismissed. It's a bit of a brain whirl, this one. Liability in relation to the resignation should therefore transfer to the transferee. But if an employee resigns under Regulation 4.9 before the transfer and also objects to the transfer, then the claim is against the transferor. Any deemed dismissal after the transfer, of course, would involve a claim against the transferee because the transfer has already happened.